Okay, we are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to the May 7th sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan. On your panel today will also be Justice Eric Nyman and Justice Catherine Hand. The usual rules of oral argument apply in this virtual oral argument, 15 minutes per side, no rebuttal. We hope that there will be no technical issues. If there are, we hope that you will be patient with us as we will be patient with you to solve them and to ensure that each party gets their full oral argument. And as a matter of manners, if you happen to see any of us on the panel look away for a moment, such as this, it's not that we are inattentive and we mean no disrespect. It is simply that we are looking to see on our paperless system, all of our records, our briefs, and the record in the case is on a screen. And so if we want to refer to something you may have said in your brief, we need to look in that direction in order to see it, but you do have our full attention. So with that, I'll call the first case, which is 19P1661, Commonwealth versus Santos. Attorney Crouch?
Yes, good morning, and may it please the court. Andrew Crouch on behalf of Joshua Santos, who appeals from convictions out of the Hampden County Superior Court. I'd like to begin today by addressing the first issue in the brief, the denial of the motion for a new trial. I think it's fair to say that we would not be here today, but for the testimony of Damian Alvarado and Jose Santiago. They were key witnesses who provided indispensable components of the Commonwealth's case. We also know that their testimony was extraordinarily problematic and riddled with lies from early points in the investigation through to trial and then even into the motion hearing. So for this, we also acknowledge at the outset that the standard of review in these cases does not favor the defendant, and certainly where the motion judge is the trial judge, it presents a tall burden, but the case law tells us that it is not an insurmountable one. And I would indeed urge this court to view this as one of those rare cases where relief should be granted, because here, there was strong evidence that two key witnesses engaged in a coordinated campaign against Mr. Santos to provide false testimony to the jury and the tribunal. At trial, Mr. Alvarado and Mr. Santiago testified and noted that they had lied during the proceedings and earlier, but they also denied repeatedly having coordinated or spoken with one another about their testimony. And despite defense counsel's best efforts, he was unable to crack that because there wasn't evidence to the contrary. Here, they're now with the motion for a new trial in the form of two independent witnesses plus documentary evidence from the Hampshire County Jail puts the lie to that. We now know that these individuals were in very close proximity to one another for an extended period. And I think when we start to look at the judges,
are these truly independent witnesses? The reason I'm saying that is because the judge found, and there's evidence that at least one of the witnesses had a relationship with the defendant. They were friends. There was also an inference to be drawn that they were potentially in the same gang or had gang affiliations. And the judge also found them not to be credible. So is it accurate to say that they are truly independent witnesses?
Sure. And let me take that sort of in reverse, and I will certainly answer the full question without any delay. Here, in terms of the credibility determination, it's important to note that the judge rejected both Mr. Sosa and Mr. Brady's testimony in its entirety. He didn't say that parts of it were true, parts of it were not, which doesn't make a great deal of sense to me because the transcript of the proceedings demonstrate that Mr. Alvarado, who is adverse, he's the Commonwealth's witness, acknowledges a great deal of what both Brady and Sosa say. They say, he acknowledges some of the context of when comments were made. He acknowledges that he had Mr. Alvarado says while at Hampshire jail, he had frequent contact with both Mr. Sosa, Mr. Santiago, and Mr. Brady, says that he frequently spoke with them about his, Mr. Santos's case, that he did not want to testify and that he had, that he was scared or anxious to do so. So the judge, I think, and a first point in terms of finding error, the judge ignores all that, or at least doesn't address any of that, where I think it's key. To address your specific question.
But the judge does make specific explanations of the credibility determinations at Record Appendix 176 and 177.
And with respect to the independence of these two witnesses, I would suggest that those findings were an abuse of discretion. And I can take them each individual witness. When we look at Mr. Brady, what the motion judge here does is he suggests that despite the corroboration that we see both in Mr. Alvarado's testimony and then also in the independent Hampshire jail records that show when he talks about these tracking of where they all are at various times, it is confirmed by those records. But the judge says here, because Mr. Brady, who comes in and testifies and says that he does know basically everybody involved in this case on both sides. He knows he has some familiarity with the defendant, though he's certainly not, I wouldn't suggest friends, and I don't think the record supports that. He notes because he was the president of a rival gang. He's not a member of La Familia. It's the Solids, as your honor knows. And he says, I act as a diplomat. I'm trying to keep the peace here. So yes, am I friendly with them? But he also specifically says, these are not my favorite guys. These are not my favorite five. These are not guys I'm hanging out with. But he's somebody they indeed know all these people from the streets and activity. Now, the judge goes further than that. And the judge says, well, because he has known these individuals, even though he knows Damian Alvarado's dad, he knows, Jose Santiago, he knows everybody in this case. So to suggest that he has bias, even though there isn't any suggestion that he favors one or the other, I don't know how the judge comes around to finding a lack of independence on Mr. Brady when he admits, I know everybody in this case. And with respect to Mr. Colon, he has known him for a long time. But it's important to note, Mr. Colon does not benefit from this motion. Mr. Brady in no way suggests anything that provides a benefit to Mr. Colon and whether or not he had engaged in a conspiracy with Mr. Rodriguez, the co-defendant here. In fact, Mr. Colon took a plea, not involved in this case, hasn't, to my knowledge, tried to use Mr. Brady as a witness in any respect. This is solely with regards to Mr. Santos, who is on a very different footing, I would suggest, than his co-defendant and Mr. Colon. And so I think that, in terms of that, there is not an independence issue with regards to Mr. Brady. With regards to Mr. Sosa, has even less of a connection to the individuals in this case. There is, testimony with regards to the gang issue, but again, he's in, at best, he is in a third gang. He's in the Neta gang or the Nieta gang. And he is not involved, with these other individuals. He doesn't even know the defendant. The defendant doesn't know him. There's no suggestion that the two of them really have any connection whatsoever. So these two witnesses don't, in my, I think the view of the record, have any incentive to lie or to favor the defendant over these other individuals. And as Mr. Alvarado testified, he was friendly with Mr. Sosa. They spent months together in the SMU talking, every day for hours every day. I don't think that there is a substantial basis to support the judge's finding with regards to independence. In addition to looking at the additional findings here, Mr. Brady testified and Mr. Sosa both testified to various points that went uncontradicted in the record. And this is not a case where these are just mere statements made in an uncontradicted affidavit where the witnesses don't eventually testify at trial. Mr. Alvarado, the Commonwealth, I don't think challenged Mr. Brady and Mr. Sosa on a lot of these relevant points. And Mr. Alvarado indeed came in, as I noted, and testified to confirm a lot of what Mr. Brady and Mr. Sosa said. The points where they start to depart from one another is in whether or not Mr. Alvarado told Brady and Sosa that he planned to lie, that Santiago planned to lie, and about the level of communication that they had at the facility, and about whether or not they were trying to coordinate, or whether or not Mr. Alvarado was being pressured by Mr. Santiago. Those are really the 3 or 4 points on which they disagree. Otherwise, there's a whole host of points which Mr. Alvarado doesn't disagree with, stemming all the way down to one of the points that the judge used to reject Mr. Sosa's testimony, which is that all three of the individuals agree that they all went into each other's cells with regularity. And while Major Hart may have said something different, those three witnesses basically confirm one another. So I would suggest that the record here, when we look at these findings, and we start at the top with all of the evidence where these witnesses testified in congruence with one another, where there was corroborating evidence, which the judge doesn't take any account for, doesn't determine whether or not that evidence would have been valuable at this trial. And here, where Alvarado and Santiago denied speaking with one another about their testimony, and indeed, Mr. Alvarado continues that lie, which he had already been caught in at trial. He continues it at the motion hearing, and indeed testifies at the hearing, I never lied at trial. We never had conversations. And that is just so absolutely patently unbelievable that it undermines, Alvarado's, credibility. And here, these two individuals provide evidence, and I would suggest independent evidence, or, we don't expect our witnesses to be perfect angels. They're all going to come with rough edges for sure. And, where all of these individuals, have criminal histories and have dealing with gangs in the streets, that is part and parcel of it. But as the Commonwealth said in its closing argument, that's understandable because these people are of the streets. The Commonwealth tried to, protect or build up, Alvarado and Santiago in its closing, based upon similar lines that the judge used to reject the testimony of Mr. Brady and Mr. Sosa. And
well,
here,
could I interrupt you just for a minute, Mr. Crouch, and go to that point and say, well, understanding that that's the case, that witnesses are coming in with, as you say, rough edges, why does that not lead us to defer even more? Why does that not underscore the need for us to defer to the trial, or to the motion judge and trial judge's assessment of credibility that was made at the motion hearing, even
because
if it seems unreasonable to you?
Because I think when we look at the particular finding, as I said, and not to repeat myself, but where the judge rejects, uncontradicted testimony, I think there's a problem there, and I think that evidence. Sorry, go ahead.
Go ahead. No, my fault. I was interrupting. I apologize.
No problem. I think that is an issue because that evidence, certainly could have come in at trial and would have been helpful here. It's important to keep in mind the jury in this case was out for 5 days. They eventually came back with a reduced verdict. It's clear that the evidence that, here, it only, the Commonwealth's case does not survive a motion for a required finding in the absence of the testimony of Alvarado and Santiago. You can't overstate how key and crucial they are to this case. And I think it was, the Commonwealth versus Liebman that talks about a situation where two witnesses are so key to the Commonwealth's case, and the Commonwealth so heavily relies upon them, and where the newly discovered evidence seriously undermines the credibility of either of those witnesses, it's crucially important that the jury hear that. And here,
I'm sorry, can I interrupt you again? And I apologize. Could I just ask, because the time is getting short, for you to elaborate for a minute on what the constitutional dimension is that you're arguing?
Sure. So here, the constitutional dimension, I think, at a bare minimum, comes across as due process and a lack of due process. And here, where the Commonwealth, and we can veer into, I would just stick with due process for this purpose. And I think the problem here is that the judge rejects outright the testimony of both of these witnesses, does not attempt to salvage or suggest that anything that they say would have been something that a jury should have heard. And I think that on its face is a rejection that is not supported even under this rarefied standard that we're looking at. And I think
that doesn't strike me under our case law as enough to transform the standard of review from abuse of discretion to the more favorable standard that you're asserting here. Just a general sort of due process because the judge didn't fairly consider kind of argument.
And I recognize that, and I certainly appreciate, as I said at the outset, the difficulty of this particular standard. But I will still contend we meet that standard, and I understand, having gone through the case law up and down.
You meet the abuse of discretion standard, or you meet the lesser standard that you assert in your brief?
I think even under the abuse of discretion standard, we're still meeting that. And I think that the trouble here is, as I said, the judge rejects at the outset all of the testimony, even where, say, 90% of it is supported by either Alvarado, Major Hart, or more specifically, the Hampshire jail records, and where the court fails to take into account that evidence. And as I said, there are, we go through in great detail in our brief, and I don't need to necessarily repeat it here. Each, taking apart each of the judge's findings and trying to find where in the record that finds support and does not find support. And I think ultimately, despite substantial corroboration from these other witnesses, which the judge doesn't account for in his findings, each of these points, certainly there is discretion that is to be given here. But I think that where the judge ignores, this greater body of evidence, there are problems that do rise to the level of something that demonstrate, problems here that need relief. And just sort of finally, as I noted, the case against Mr. Santos was far from overwhelming. It was these two witnesses who really held the keys. And there, we cannot divorce this from the context of understanding that these two witnesses, it is not too much to say that they are liars. These are people who have lied in the case from the very earliest points, admitted lying in their testimony. They got caught in lies in trial where they literally, the next sentence is out of their mouth there. What I just said was a lie. Alvarado continued to do that at the hearing. Here, with very few exceptions, I don't think the trial judge is finding that these two individuals lied. Mr. Sosa and Mr. Brady is finding that they might have some sort of bias issues, or they might have other points. But really, when it comes down to it, this court has the power to intervene in circumstances where justice may not have been done. And in this case, I would urge the court to be left with the determination that indeed, in the circumstances with these two witnesses who have pretty clearly, by my read of the record, engaged in a coordinated campaign of perjury and lies to defraud a tribunal and to essentially frame Mr. Santos, in the absence of other supporting evidence, I would ask this court to reverse the denial of the motion for a new trial and order a new trial for Mr. Santos.
Any questions? Thank you, counsel. Exactly 15 minutes. Attorney Lynch.
Good morning. May it please the court. Oh, my time. There we are. May it please the court. Travis Lynch, Assistant District Attorney for the Commonwealth. Just to turn to the motion for new trial issue, the judge, after having an evidentiary hearing, found that the two witnesses who advanced the allegedly newly discovered evidence were not credible. And I think the SJC's case law, cases such as Walker, make pretty clear that the appellate court does not revisit the judge's credibility determinations. So it seems as though we've had a really elaborate argument here to have this court second guess Judge Agostini's credibility determinations of these witnesses who testified at a hearing. And the judge said, I don't believe these witnesses. The appellate court cannot substitute its view of the credibility of the witnesses for that of the judge. And I would suggest that the judge was free to accept in whole, in part, or none of the testimony if he so wished. And he did explain his reasoning in the memorandum of decision, as Judge Nyman pointed to earlier. And once you accept the fact finding, or once you accept the credibility determination, it follows naturally that there is no newly discovered evidence and the judge does not abuse his discretion in denying the motion under these circumstances. And I cited in my brief cases like Sparks and Rosario and so forth. And in Sparks, the SJC specifically held, once the judge found that the witness who advanced the newly discovered evidence was not credible, he didn't abuse his discretion in denying the motion as a whole. And that's really all there is. I think that's really all there is to this case. And to just touch on the question about if this is a constitutional claim, a motion for new trial is a common law based claim. It is not a constitutionally based claim, unlike, say, ineffective assistance of counsel. So I think the case law pretty clearly answers all of the questions on the motion for new trial. Unless there's any further questions about that, I think that suffices.
I have a question about the second issue, the furtherance of the joint venture. As I understand it, you suggest in your brief that there's sort of a two-prong analysis here. The first is the judge makes a determination of law as to whether or not the statement is admissible under our rules of evidence as a statement in furtherance of a conspiracy, and there are elements to that determination. I think you then suggested that the case or that issue is then supposed to go to the jury as a question of fact. Am I understanding your argument correctly?
It does seem as though, I mean, yeah, the SJC does require, for some reason, that evidentiary question be submitted to the jury. I think it's in the same category. There's a few evidentiary questions like that seem to go to the jury, like dying declaration, and I believe also that there's also the humane practice area. So the jury, yes, that does seem to be what the case law states, and the jury did receive the instruction, as they were required to, that they had to independently determine whether the statement was in furtherance of a joint venture.
What case stands for that proposition? That
I believe
analysis that requires a jury instruction.
I believe it was Bright. I believe Bright was the case. If I'm remembering that correctly, that wasn't really. Yes, it was Bright. I mean, I don't think that's really the defendant's argument on appeal, but I don't think he's challenging the jury instruction. I just pointed that out. So in addition to the judge's initial admissibility decision, the jury also seems to have a role in determining whether the statement was made in furtherance of the joint venture.
Does it matter? I think your brother alludes to this, that I believe it was Santiago had ostensibly withdrawn from the conspiracy by refusing to do the shooting, if I have my facts correct.
That sounds right.
If that is correct, then how can the subsequent statement to someone who withdrew from the conspiracy be a statement in furtherance of a conspiracy?
Well, I would say
or
that
furtherance. I should say in furtherance of a co-venture.
Well, yeah, that's sort of 6 of one and half dozen of the other. It's really the same thing. But to actually answer your question, I would say, Santiago still is in the gang at the time that the statement is made. And to really address the defendant's point, there's no requirement that the person to whom you make the statement, the person you're talking to, actually be in the joint venture. So I think that's a red herring from the get-go. That's just not a requirement of the doctrine. And all the cases that I cited not all of them, but a good deal of them, like Raposa, for example, one of the people in Raposa was not involved in the murder, but still telling them about the crime was still in furtherance of the joint venture. So telling someone who withdrew, I don't think that the fact that he withdrew matters for admissibility, because still keeping him on board so that he doesn't go and tell the police, which is an inferable purpose of sharing information with him, is still in furtherance of the joint venture. And I think that, are there any more questions about that issue? The other issue relates to the unpreserved claim that the teardrop tattoo testimony as a lay opinion was, I believe the argument is that its probative value was substantially outweighed by the risk of unfair prejudice. I would just observe there was no objection on that ground. The probative value that the shooter made an implicit admission that he had murdered someone is quite significant. And then when you look at the record, you can see that the jury were screened to make sure that they wouldn't be unfairly prejudiced due to gang involvement in the case. And also the judge gave warned the jury not to draw propensity inferences from gang membership. So on this record, viewed through the lens of unpreserved error, there's no chance of a substantial risk of a miscarriage of justice on the admission of the tattoo evidence. And unless the panel has additional questions on this, I would be content to rest on my brief.
Panel?
None here. Thank you.
Thank you.
Seeing none, thank you very much. And we wish you, as the court year winds down, and as hopefully this pandemic winds down, we wish you both good health in the spring and summer. Questions?
All right. One moment. All right, we are live and recording.
Good morning, everyone, and welcome to the May 7th sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan, and with me today are Justices Eric Nyman and Catherine Hand. Together, we will be your panel today. The usual rules of oral argument apply in this virtual setting. Each side will have 15 minutes to argue, and there will be no rebuttal. We sincerely hope that we have no technical issues today. For those of you who are watching on YouTube, if for any reason we do have a technical issue, your screen may go dark for a while we resolve it, but we will be back. We ask only that all of you be patient with us as we will be patient with you. And if for any reason you notice any of us who happen to look away from the screen slightly, it is because our case materials, our briefs, and the record are to one side of the camera or another, and we may wish to refer to them during the course of oral argument. We mean no disrespect, and you have our full attention. So with that brief introduction, I will call the next case, which is 20P0125, Commonwealth versus Dennis Saxton. Attorney Schneiderman.
Good morning, Your Honors. May it please the court, I am Joseph Schneiderman. I represent Dennis Saxton. I plan to focus this morning on the issue of the prolonged stop and the voluntariness of Mr. Saxton's statements. If the court has questions, though, about the issue of an arrest in fact, I'm happy to answer them. Your Honors, exit orders are the exception and not the rule, and the lawfulness of a seizure turns on what the police actually do. Lieutenant Shagru here played out a hunch to distend the stop without objective and articulable facts, and suggesting that impairment justified the entire encounter is ultimately unreasonable in light of the record. Your Honors, I want to start by pointing out the stop was valid. Trooper Shagru observed speeding and unsafe lane changes. Those were grounds for a valid traffic stop. Trooper Shagru likewise had reasonable time to complete the stop and any investigatory inquiries. The standard, though, of timeliness is articulated in Cordero, which is when the stop actually or reasonably should have been complete, and the facts of the that demonstrate the lawfulness of the stop turn on what the police actually do to complete the stop. In this case, Trooper Shagru called for backup and was writing a warning, and backup responded, and whatever extra time he needed to finish writing the warning or to make the out-of-state record check, which I grant perhaps merited some additional time, ultimately dispelled suspicion and could not justify further prolonging the stop. Put another way, Trooper Shagru, I'm sorry, Justice Hand?
Mr. Schneiderman, given the fact that the officer had seen what might be characterized as erratic driving, the operation of the vehicle, the failure to stop until the passenger had popped back up again from the floor, the nervousness of both, if I'm remembering correctly, the passenger and also the driver, would Shagru have been within his rights to have done some preliminary questioning about intoxication before running the licenses?
Your Honor, I'm glad you asked me that, because Trooper Shagru, in fact, actually did ask some investigatory questions. He asked Ms. Gilbar, "What were you hiding?" She said nothing. He followed up with Ms. Gilbar and said, "Are you okay?" in light of the nervousness. And Ms. Gilbar said she had asthma, and Trooper Saxton, or I'm sorry, getting the characters here confused. Trooper Shagru said, "Do you want an ambulance?" Ms. Gilbar said, "No, I have an inhaler." So Trooper Shagru had some questions he could have asked, and he did in fact ask, but he went awry in what happened next. So I agree with Your Honor that there were some, I'm sorry.
My question is a little different, though, as far as the driver is concerned. For your client, would Shagru have been justified in asking questions about that person's sobriety that would be maybe lead-ins to the questions that, or to the field sobriety tests that were ultimately done? I guess maybe a better way to ask that question is, was there a basis for preliminary questions, not necessarily investigatory questions, at the driver's side window based on what the trooper had seen before the trooper did the license check?
Your Honor, that actually goes to my second point, which is the gestalt. The Commonwealth and the motion judge here are asserting that this is a impairment-based stop. The facts in Trooper Shagru's knowledge when he got to the window and encountered Mr. Saxton, at best, simply belie that, and at worst, overextend what are suspicious facts. I'll unpack that a little bit. Trooper Shagru did not find an open bottle of alcohol, drug paraphernalia. Trooper Shagru encountered Mr. Saxton, who was visibly nervous. Yes, the infractions are, I think, are merited a query, but there was no information about impairment when Trooper Shagru actually reached and encountered Mr. Saxton.
Well,
And
there had been what could be described as erratic operation. And the trooper approached. He did not smell alcohol. I believe he followed somewhat the same protocol as in the Washington case. And it may have even been the same trooper. But would he have been permitted to make inquiry concerning drug use of the operator at that time? I think Justice Hand has the right question. And indeed, he did the eye test. So could he have done the eye test right away?
Your Honor, I want to clarify something. The eye test didn't happen until the backup troopers arrived. It was Trooper Meikle who
I understand, but I'm asking you, could he have done it right away?
Not without something more, Your Honor. To Your Honor's
Why is the erratic driving not enough?
Your Honor, there was nothing at the time Trooper Shagru got to the window. I agree with Your Honor. At worst, we may have negligent operation here, and certainly negligent operation, someone should come off I-91 that way. Trooper Shagru, though, did not observe at the window bloodshot eyes, slurred speech, or any of the other classic indicia we think of when we are considering exit orders for impaired driving. And in any event, I think the record makes...
Those are indicia for alcohol impairment. And if what they suspect is drug impairment, how are they supposed to figure that out? What is a permissible inquiry?
Your Honor, without backtracking or stepping back from my point, I think there could be an inquiry, but I think the record here just does not bear out enough to justify the inquiry. I appreciate Your Honor's point that bloodshot eyes and slurred speech go to operating under the influence of alcohol, but they can be similar as to drug use. That's the SJC's decision in Davis. So
let me ask it this way. Assume, conceding, assume that there was enough here for Trooper or Sergeant Shagru to appropriately perform or ask your client to perform field sobriety tests or to give them the nystagmus test, okay? Just assume that.
Sure.
Is there anything wrong with, instead of doing it right then and there, with the trooper calling for backup, waiting for them to arrive, and having them do the same?
Your Honor, again, I think the record just does not bear that out.
I'm asking you to assume for purpose.
No, I understand. I'm sorry, Your Honor.
That there's enough for Shagru to do so. Instead of doing it then and there, he chooses to call for backup, go back and run their records, and when backup arrives, have them conduct those tests. Is that in that scenario, and I understand you're saying that is not, those facts are different, but under that scenario, is there anything constitutionally improper about that tact?
Yes, there is, Your Honor. It would collide with Cordero, which says the tasks to complete the stop must be reasonably completed. And that actually leads into the issue here, which is Trooper Shagru had returned to his cruiser and was writing a warning for speeding. And it harkens to my original point, which is the reasonableness here depends on what the police actually do. Trooper Shagru was prepared to let two people continue all the way through Massachusetts and into northern Vermont with a warning for speeding. The backup did not arrive for 10 more minutes, and the exit order occurred 20 minutes into the stop. So I think even though it may be the better practice, such a holding would need its own freestanding articulable facts, and there aren't those freestanding articulable facts here.
So you're saying if the police believe that someone is under the influence, if they don't conduct field sobriety tests forthwith, but instead call for backup and wait until the scene is more secure in their view, doesn't matter. It's done, it's out, it's constitutionally infirm as a matter of law.
Your Honor, calling for backup may be the most salutary practice, but given that a trooper has a duty of care, I mean, that's what I mentioned in the reply brief, a trooper has a duty of care to take someone he knows who is impaired off the highway. The trooper must pursue the most expeditious course of conduct to take the impaired person off the highway. And the facts in the record here just, I think it overburdens those facts to add it up to impairment here.
So you've honed in on my question. Exactly. What case or authority stands for the proposition that an officer is required to take the most expeditious route possible to have a defendant perform field sobriety tests or to check?
Your Honor, this court has never said as much in that articulation, but certainly the past decisions involving exit orders, the timelines pale compared to this one. Eckert, for example, I believe Trooper Shagru was the trooper in Eckert. Eckert, he encountered someone in the rest area elsewhere on I-91. He shined the light. He had the person come out of the car. We also don't have any articulable facts about Route 91 as a drug corridor or Trooper Shagru having made OUI arrests. I think more to Your Honor's question, it would be a sea change here to say that OUI drugs somehow justify this. And the theory below was, the question below or here is, was this stop justified for criminal activity or officer safety or any of that? So I think in the end, the sum of what has occurred here just belies this suggestion that it's an impairment-based stop. And I'd actually like to walk through the timeline here. The backup arrives 10 minutes after Trooper Shagru calls. The exit order happens 20 minutes after the stop has begun. The dog arrives 40 minutes later, and the stop ultimately concludes after 50 minutes. So I agree with your, I'm sorry, Justice Sullivan?
No, finish what you were saying.
Yeah, please.
Oh, I was about to say, if the reasonableness of an encounter or if the lawfulness of an encounter turns on what the police actually do, the sum gestalt here is that the police operated and turned fact into more suspicion than there was. And I think in light of the SJC's decision in Cordero that you don't get bonus time or you can't extend a stop to exhaust every avenue of inquiry, and the reaffirmation in Barretto that nervousness has less weight in the analysis, the stop was faulty. I'd actually like to turn to the Miranda issue, if I may.
Actually, before you do, I just want to check to make sure that we are on the same page as to the sequence of events here. And I also wanted to correct before I referenced a Washington case. I meant Wright, and there it appears to be the same trooper. But the sequence of events, if I understand it, is that the strabismus test is done on the driver. The criminal record check then comes back. The Miranda warnings are then given, and the field sobriety tests happen thereafter. Is that correct?
Not quite, Your Honor. If Your Honor is articulated as 1, 2, 3, 4, which is the Gismus check, the record check, the backup arrives, and the sobriety test happen, it's actually 2, 1, 3, 4, which is the record check, the backup, I'm sorry, 2, 3, 1, 4. The backup arrives, the troopers administer, the record checks start, the backup arrives, the trooper administers the negationist test, and then the sobriety tests occur. And actually, Your Honor is correct.
You said that the record check begins or the record check comes back. When does the record check come back in your view?
Your Honor, the record check was in progress and completed as the backup were arriving, which is why this takes into the ambit of Cordero. And actually, Your Honor, I was looking at Wright this morning, and Wright also involved then Trooper Shagru. He is now a lieutenant. I'm sorry if I've been wishy-washy about that.
Right. Okay, but definitely the record check is returned before the field sobriety tests are conducted.
Yes, Your Honor, that's precisely
okay. That's my point. All right, you wanted to make another point.
Yes, I do, Your Honor. I know I'm running out of time. I just would like to emphasize 3 points as to the Miranda waiver, which is the judge made an express finding of custody here, and indeed that custody occurred when complete Miranda warnings were administered 20 minutes in, and threats directed to family members or loved ones or promises of leniency are coercive. And in the end, the circumstances of this stop are the hallmark of why we have the Miranda rule. Mr. Saxton and Ms. Gilbar were isolated and outnumbered on the side of the highway 4 hours from home and subjected to repeated questioning over and over about drug use and drug possession. And the troopers took it further by intruding on Ms. Gilbar. I leave more of that to counsel for Gilbar. In the end, Your Honors, the troopers played and escalated a successful hunch from, as this court has articulated, zeros. The Constitution forbids such hunches from justifying such dramatic intrusions into our liberty. I ask that this court reverse and suppress the evidence.
Any further questions? Seeing none, thank you, counsel. Attorney Payne.
Thank you, Your Honors.
Good morning. May it please the court. Cynthia Payne for the Commonwealth. The Commonwealth is asking this court to affirm the motion judge's denial of the defendant's motion to suppress. Here, the Commonwealth adduced sufficient and articulable facts warranting the detention, the extended detention of the defendant. Here, as counsel for the defendant has conceded, the stop was valid. The sergeant observed speeding. He observed as the motion judge also found, the defendant was swerving within the lanes, and certainly, as the motion judge credited Sergeant Shagru, those were facts that certainly satisfied a impaired a operation under the influence sort of stop. The motion judge credited Shagru's testimony that he called for backup. And I would suggest that Cordero is very distinguishable here. In this case, Trooper Shagru was still engaged in the tasks involved in both the speeding and the operating under the influence. It's somewhat unclear, I would suggest to you, where the sergeant was in this check when his backup arrived, but it was clear because he was still engaged in those tasks. He asked the backup troopers to speak with the defendant and the passenger to find out what was going on while he finished those tasks. And I would suggest in Cordero, because the trooper had done a lot of preliminary work, he already had the records, he already knew that the plate was valid in that car. Because he had done all that preliminary work, as opposed to this case, it's very distinguishable. And I would suggest that Buckley is certainly a very good case for the Commonwealth. And in that case, certainly the SJC found that the trooper did not exceed the scope of the stop by extending the detention.
Let's assume, for the sake of argument, that there's enough for an exit order here, enough to administer field sobriety tests, enough to administer the exit order. What authority is there that the police officer can then, under these circumstances, seek consent to search the car right then and there?
Well, I would suggest that as the trooper, actually, I don't recall which trooper was speaking and administering the roadside assessment. I believe it was either Milky or Tudrin. But while Sergeant Shagru is waiting, and while Defendant Gilbar is waiting, Shagru is speaking with her, and based on her furtive movement they had noticed before, based on her excessive nervousness, based on Mr. Saxton's excessive nervousness, this was not an extension of anything, because Mr. Saxton, the driver, was out of the car, and I would suggest that the sergeant was well within his rights to speak with Ms. Gilbar.
Of course, he can speak with her. The question is, what case authorizes him to seek consent? And I guess what I'm really looking for is any case that has somewhat parallel facts. The answer is just that it's a fact-specific inquiry, and you don't have one. That's fine, but it would be helpful.
I would suggest yes. I don't have one off the top of my head. Of course, Ms. Gilbar, and this was a very fact-driven, as the motion judge found, this was an evolving situation. We have an initial traffic stop, roadside assessment, possible impairment, based on the movements of the co-defendant, based on, again, their demeanor, based on the record check that came back. I would suggest that the troopers, and as the motion judge found, were able to continue along this. They had reasonable suspicion based on these facts. They asked for consent. Ms. Gilbar consented. I expect we'll probably talk about that in the next argument. And once the troopers searched the car, they found indicia of possible body packing. The motion judge credited the fact that both Sergeant Shagru and Trooper Tudrin, based on their training experience, were well aware that both the condoms and the little black elastics, along with the money that was found, were indicia. And I would suggest that every step of the way there was sufficient evidence and gave reasonable suspicion for the troopers to continue on along this path. Did that answer your question, Your Honor?
Yes, and we can also explore it further in the next.
I will touch briefly on my brother's third issue. Here, the motion judge determined that both the Miranda waiver was voluntary, based on the defendant's willingness to answer the questions and their continued willingness to answer the questions. I would note that the trooper nor the sergeants ever referenced the baby, and there's certainly no evidence in the record as to that. I would suggest that this is a case.
Did they have to? Maybe this is a question better left to the next argument, but the offer to let them go versus arrest them on the spot with a baby in the back, they don't need to say too much more, do they?
Well, I would suggest that this is not the Monroe case in which the police officer excessively referenced the child. This is not a case like that. In fact, this is not a case in which the troopers or the sergeants employed any sort of deceit. The motion judge found that they understood their Miranda rights. There was certainly no evidence that the questioning was hostile, and I would suggest that it was. Then they certainly neither were taken into custody. There was no evidence that they were placed in the cruiser or cuffed or restrained in any sort of way. I would also suggest that that the defendant's prior convictions show that they had the fact not just arrest, but they had prior convictions, so they have familiarity with the legal system. So I would suggest, based on that, this defendant's will was certainly not overborne. Unless the panel has further questions, the Commonwealth would rest on its brief.
panel. All right.
All right, we are live and on the record.
Good morning, everyone, and welcome to the May 7th sitting of the Massachusetts Appeals Court. My name is Mary Sullivan, and on your panel today will be Justice Eric Nyman and Justice Catherine Hand as well. The usual rules apply in this virtual oral argument. Each side will have 15 minutes in which to present their case, and there will be no rebuttal. We hope that there will be no technical issues. For those of you who may be watching on YouTube, if we do have one, your screen may go dark for a moment. Rest assured, we will be back. We only ask that you remain patient with us as we will remain patient with you. And finally, if you happen to see one of us look to one side or another of the screen during the course of oral argument, we mean no disrespect. Our briefs and other papers and notes may be to one side of the camera or another. We are simply referring to them, and you have our full attention. With that, I will call the next argument, which is 20P0126, Commonwealth versus Amanda Gilbar. Attorney Rivera.
Thank you, Your Honors. Good morning. May it please the court, Attorney Juan M. Rivera for Ms. Amanda Gilbar. Your Honors, there can be nothing more humiliating for a woman than being forced into a situation where she's made to wait at the side of a highway for 50 minutes while her child is in a back seat and cannot leave until she submits through various types of coercive behavior by police officers to submit to a body cavity search, a self-imposed one, to avoid the officer's requirement to obtain a warrant as required by the law here in Massachusetts, specifically Commonwealth versus Agogo and Commonwealth versus Genus. I did not cite Agogo in my brief, but that is 481 Mass 633. Your Honor, Your Honors, I just want to get out of the way. I adopt the argument that I just heard Attorney Schneiderman made in its entirety with respect to those issues and how it pertains to Ms. Gilbar. But I'd like to focus, unless there are other questions, on the actual search that occurred from Ms. Gilbar.
I do have I'm sorry to interrupt. I do have a question before you get there. You state, I think 3 or 4 times in your brief that the primary illegality here is when the trooper asked your client for her license. And I don't see any case law or authority that I can find that supports that proposition. So what are your best cases that say that in a situation with facts similar to this, it is inappropriate for the trooper to ask for the passenger's license?
Well, the Cordero case, I believe, is the most similar case. The facts are not exactly on point.
Right.
However,
Cordero didn't have the concerns at issue here. Cordero didn't involve a car that, after the blue lights went on, continued for another quarter mile. It didn't involve fact where the passenger leaned forward and was totally out of sight, and the car did not pull over until the passenger popped back up. So I think Cordero is likely distinguishable.
well,
I mean, don't those facts combined with her extraordinarily nervous behavior and the fact that she indicated that this is her car, don't all of those factors combined justify the trooper asking for her license in this case?
no. And the reason why, Your Honor, is because the reason that the trooper asked for her license was because she volunteered upon questioning that she was the owner of the car. She had the registration. She handed him the registration, and he wanted to check her license to make sure that she was telling the truth about the registration.
But
So
our case law tells us, I'm sorry to interrupt, but our case law tells us we don't just look at the subjective manifestations of the trooper, we look at all of the objective totality of circumstances that were known to the trooper at the time.
The case law also suggests the reason that there's a reasonable officer standard as far as Article 14 is concerned. So I would suggest to this court that a reasonable officer who believes that there is a reason to take a passenger's license has to have articulable reasons for doing so. The only articulable reasons and reasonable articulable reason, is that she might not be the owner of this vehicle, but he had the registration, which had her name. He already saw her name on the license. He did not need to take her license. He could have gone back to the vehicle, checked there with a registration that he was required to obtain and did obtain, and dispel or confirm any suspicion at that point. And that's the reason why I don't believe the trooper had the authority at that point to take her license. She did not have her seatbelt unbuckled. She didn't have any other reason she did not give the trooper any other reason to obtain and retain her license. And so that is why I point that out as far as Ms. Gilbar is concerned, why that is the primary illegality with respect to her.
So when you say, so you seem to be clarifying, I'm sorry to interrupt again, but in your brief, you say the primary illegality was that the officer didn't have valid grounds to require her to produce her driver's license. And as I understand your argument here, you're clarifying that it was okay for the trooper to ask for her driver's license, but that it was wrong for him to take it back to his vehicle. Is that a distinction you're now making?
No, I don't believe the trooper did not ask for her license. She had her license. She took her license out. He then took her license, which is what I'm arguing he did not have the right to do.
Okay. By the way, I think someone has the YouTube feed on in the background. And if you do, please turn it off. That's why we're getting a reverberation. Thank you.
I just checked, it's not me. Thank you, Your Honor.
Maybe construction noise. When did he give the license back?
I don't believe that the facts indicate that, so I can only assume that it was at the end of 50 minutes after multiple unsuccessful searches were conducted throughout the 50 minutes. And so the timeline, I think, is important. Attorney Schneiderman, my brother counsel, pointed out the timeline. I think it's very important. In 10 minutes, there's a lot that can happen. The trooper Trooper Shagru, when he went there to the stopped vehicle, had every opportunity to make the observations that were later said to be made by the troopers Truden and Milky. And he did not, which I believe goes towards the credibility of how this stop slowly but surely was transformed into an illegal search and seizure, ultimately culminating in a acquiescence, I would argue, by Ms. Gilbar to engage in a search that would have been unlawful for them, the troopers, to do. They could have obtained a warrant. I don't know if you guys are from or are familiar with 91, but literally in view of the courthouse, you can see the courthouse from 91. And with flashing lights, you can get there quite quickly and obtain a warrant if that is what you need to do. So the argument is that the troopers, by extending
we're concerned about the delay, 20 minutes, 30 minutes. Are you suggesting then the troopers could freeze the scene and obtain a warrant right then and there, which would probably take a minimum a period of hours?
If the troopers had probable cause, then yes, but they didn't. And that's why they continued engaging in the behavior that they did, which was to multiply their force and their presence on the side of the road and involve dogs even. And the dog even did not signal that there was anything. So again, there were multiple unsuccessful attempts by the troopers to search for to engage in speculative criminal investigation. The fact is that after 40 minutes, 40 minutes is when the canine arrived, and this was already after the troopers had searched the vehicle and found innocuous zeros, as Commonwealth versus Torres articulates in that case, about multiple zeros don't add up to probable cause or reasonable suspicion. There's nothing illegal about what they found. And for them to continue to insist
which Torres case are you citing to there? Because I think there's 3 of them cited in the briefs.
Certainly. That would be Commonwealth. Sorry.
No,
424 Mass at 16. It's at 161. The zeros quote. That's that case. And so again, there's a big deal made out of a furtive movement that was seen and observed as a reason for further escalation. I would suggest to you that what was observed is consistent with somebody dropping their phone, somebody dropping any innocuous item, going to pick it up. You were the passenger, and Ms. Gilbar was the passenger, and the police's mission at that point was focused on the speeding violation that they had observed. And so at that point, the mission of the police officer is to address that particular issue, to further extend and distend the stop, to then later, by implication, and there was something said about this, how nothing was said to her because nothing had to be said about her child in the back seat. And so I think that there are some credibility determinations that you can revisit, and those are borne out by the fact that a reasonable police officer who legitimately feared for his safety as what's being presented would have called prior. And the fact that he was writing a warning to address the mission of the stop and then sent 2 other troopers to, for lack of a better word, stall, and then dogs and further troopers, I think it suggests that what really was going on here was criminal speculative investigation by the troopers. In the end, Ms. Gilbar was subjected to a lengthy and coercive environment where she could not leave. She was detained. She had her license in the possession of the police officer, and they weren't going to take no for an answer. And ultimately, that is the environment, that is the climate in which Ms. Gilbar finally relented and allowed the officers to evade the requirement of a search warrant. Your Honor, the fact that the stop lasted for this long, and then at the end, they were allowed to drive away, again, I would suggest shows there is no reasonable officer protocol being followed here. I would hearken to the Ware case, the town of Ware case, where if this was legitimately an issue, this stop would not have happened the way it did. They would not have been allowed to travel to Vermont in that manner. And so I would suggest to you that a closer and a new look at the facts support our request here that the evidence in this case should be suppressed. And if there are no other further questions, I have 30 seconds. I would rest on my briefs. And again, I'll just state I do join Attorney Schneiderman in his argument for Ms. Gilbar.
Seeing no further questions, thank you very much, counsel.
Thank you very much.
And as soon as you see the blue box, Attorney Payne, you may begin.
Thank you. Good morning. May it please the court. Cynthia Payne for the Commonwealth. The Commonwealth is asking this court to affirm the motion judge's denial of the defendant's motion to suppress. I would just like to quickly touch upon the fact that the motion judge credited Sergeant Chagrew's safety concern when he called for backup. And I would also point out that the record does not show that Sergeant Chagrew actually physically took Ms. Gilbar's license, but even so, I would suggest Commonwealth versus Wright, which Justice Sullivan, you had mentioned earlier. This was a similar case, the same trooper, and in that the court had indicated where the passenger claimed to own the vehicle, the court found no issue in the trooper's request for identification. I do know that—
Counsel, could you articulate for me what the safety concern was with two nervous passengers and a baby in the back seat?
Well, I would suggest that the concern arose when Trooper Chagrew pulls out after the defendant's passed. He's speeding. Defendant Saxton is speeding, swerving. Sergeant Chagrew activates his emergency lights, and Sergeant Chagrew sees at that point Mr. Saxton look over towards the passenger seat. At that point, Ms. Gilbar, who's the front seat passenger, bends completely out of sight. In addition—
So at the time he calls for backup, what is the safety concern?
Well, because he's already seen that furtive movement.
But what are you saying that meant? What do you think? What factual basis is there for the safety concern?
I would say based on the prior furtive movement, based on the very excessive—
Could have been baby wipes. Are you saying that the trooper could have believed that there was a gun in the car? I'm just trying to decide.
Certainly, he could have thought that. I know the motion judge credited that, and I believe there's certainly—
He didn't credit that. That's the reason why I just asked you to flesh it out a little bit. He said safety concerns. It isn't your average safety concern case with a baby in the back seat. That's all.
But I think the fact that Ms. Gilbar bent over, the sergeant sees how excessively nervous she is. And I would suggest that police officers, case law Cabrera, which is a different case certainly, but police officers don't have to gamble with their safety. He knows something's not right. There's been a movement. She could have been hiding something. Just because there's a baby doesn't mean there's not a gun.
Did there have to be safety concerns in order for him to call for backup, or could he have just called for backup?
I think he could have called for backup, but the fact that he felt concerned based on the furtive movement, and I rely heavily on that I think there's certainly quite a bit of case law that says a person bending out
I'm
of
just
sight.
asking you to hypothesize that you take that out.
If I take that out,
If you take that out, could he have called for backup, given he had two extremely nervous people, one of whom was shaking, and an initial failure to stop?
well, I think he could have, as long as he didn't prolong. I think what the case law, what Cordero says, police officers can't extend. So I think he could have called for backup without the furtive movement, as long as their arrival didn't extend his task, because he still had to run checks. He still had to make sure checks on licenses and checks on the vehicle's registration. So I think, again, as long as it didn't extend that stop, he could have. But we do have that extra fact. Did I answer your question,
Yes,
Your Honor?
thank you.
I know this court is very interested in the consent issue, so I will delve into that.
Before you get there, what case authorizes trooper in a case like this to seek and take the license from the passenger?
Well, I think my best case is Wright, although it's unclear in that case whether the trooper just asked for the identification or he actually took her license. But again, because the passenger in the right case, as here, claimed to own the vehicle, the court didn't have any issue with that. And I would suggest that the Torres case, the 424 mass, it is distinguishable in that case, because the police officer, or the trooper in that case, had confirmed all the details regarding the license of the driver before he got the information from the passenger. The court said that was not okay, but there was a footnote in that case that said the order was really important, that if he had asked, I believe it's footnote 8, that if the police officer in that case had questioned the passenger prior to validating the driver's information, that it would have been okay. Kimball is another case which I think is distinguishable. Alvarez is distinguishable. I believe Alvarez says a police officer can't automatically ask for the information, but here we had the furtive movement. We have Ms. Gilbar, who says she owns the car. So I think those cases are different. Did that answer your question, Your Honor?
Yes.
In regards to the consent issue, here we have Mr. Saxton, who has already been taken out of the vehicle to perform the roadside assessment. The trooper had asked him to do so. Meanwhile, Sergeant Chagru is speaking with Ms. Gilbar. I would suggest that, and I don't have a case on point, that the trooper was entitled, that Sergeant was entitled to ask her if she would consent to a search of her car. And I would suggest that the factors that a court looks at in determining whether it's voluntary, certainly the majority of those favor the Commonwealth. Here we have Ms. Gilbar, who's, I believe the record indicates that she's about 25 years old. She has prior police familiarity. She's been convicted previously. We certainly have no evidence that the police used any sort of trickery or deceit to get her to consent. Certainly Ms. Gilbar was very, very cooperative. There was no evidence that she balked or said no, or I want to talk to somebody. In fact, later on, and I'm not bootstrapping, but I am pointing out that later on, when she asked if she could speak with Mr. Saxon, she was twice, they were allowed to convert privately. I do know that Ms. Gilbar was not advised that she could refuse, but I would suggest that that's not determinative of her being, of there not being voluntariness in the consent. And I would suggest the fact that Ms. Gilbar knew that the troopers and the sergeant were not going to find anything, because she knew where the contraband was, and the contraband was either on or in her person. and I would suggest that her knowledge that that the search was not going to, in her mind, reveal anything incriminating is a factor that the court can take into consideration. I don't have the name of the case off the top of my head, but I do know.
I'm not following that at all.
So, Ms. Gilbart, I would suggest, knows where the drugs are. She. In any event, even if we bypass that, I would suggest that the majority of those factors favor the Commonwealth, and I would suggest that the motion judge did find that she voluntarily consented to the search of the car. I would suggest this case was a step-by-step involvement. We have the motor vehicle infractions. We see the furtive movement. We see the demeanor. The trooper takes he shows signs of impairment. He's taken out for the roadside assessment. I would suggest that based on the officer's training experience in conjunction with the evidence that was found, the condoms, the elastics, the money, I would suggest that gave the trooper's training experience reasonable suspicion to believe that Ms. Gilbar was, as the motion judge and troopers stated, body packing. I would suggest that she, after, when she was asked again, I would suggest that she was given 2 opportunities to speak at her request with Mr. Saxon. And after the first conversation, she in fact turned over heroin. And at that point, certainly there was probable cause based on the evidence that had previously been found, based on the officer's training experience, to believe that there was additional evidence. If the panel has no further questions, the Commonwealth would rest on its brief.
Seeing none, thank you both very much.
Thank you, Your Honor.
Thank you.
All right, we are live and on the record.
Good morning, everyone, and welcome to the May 7th sitting of the Massachusetts Appeals Court. My name is Mary Sullivan. Your panel today will consist of me, Justice Eric Nyman, and Justice Catherine Hand. The usual rules of oral argument apply in our virtual setting. There is to be 15 minutes of argument per side with no rebuttal. We hope that there will be no technical issues, but if there are, we hope that you will be patient with us as we will be patient with you. For those of you who may be watching this on YouTube, if we do have a technical issue, your screen may go dark, but rest assured we will return. And finally, if you see any of us look to one side or look away, we mean no disrespect. You do have our full attention. It's just that our case materials may be to one side of the camera or another. With that, I will call the next case, 20P0335, DOE number 525918 versus Sex Offender Registry Board, and this case is impounded. Counsel Stiles.
Yes, Your Honor. May it please the court. My name is Attorney Ethan Stiles, and I represent the petitioner in this case. And he is here today because he made an error in judgment over 10 years ago, but one that shows no evidence of reoccurring, no real risk. But the hearing examiner committed several errors in her decision which warrant reversal. And this case started off with the petitioner filing a motion for relief from registration, and the Superior Court at first remanded it back to the hearing examiner after the hearing examiner held that the petitioner had a burden to show by clear and convincing evidence that he was not a danger, and the Superior Court said no. The board has to show by clear and convincing evidence that he is a danger. But the hearing examiner merely just revised whatever words that needed to be revised in her decision to make it conform to what the Superior Court requested, which suggests a superficial fact finding intending to glorify a conclusion.
Attorney Stiles, where in the hearing officer's findings do you think she shows that she's putting the burden incorrectly on Doe?
Well, she started that way. She started off when the hearing was first held, and the first decision that she did apply the burden to Doe to show that he had no risk. And when you look at that decision, then you look at the amended decision. The amended decision is virtually identical, apart from that language that deals with that situation. And there's one adjustment to probation issue that I'll get to. I could say that really nothing has really changed. She just went through the motions, but still, her consideration hasn't really changed. She didn't really do anything differently.
But are you saying that the findings that she made and the assessments that she made don't support her determination that under the applying the burden of proof properly, that a level 1 was sustained? Yes,
I believe I am arguing that. And that brings me to the specific errors, and the first of which is the attribution of the other man's conduct to the petitioner's conduct. Now, we have a situation where both individuals were charged, but they were not charged as joint venturers or charged as co-conspirators, and didn't even know each other prior to this offense. But by the end of her decision, the hearing examiner is effectively condemning the petitioner for not intervening to stop or discourage the other man's conduct, which appears to be more invasive and less appropriate than his.
Where, other than on page 13 of the decision, in that first full paragraph, does that surface in the decision?
Hold on here. Let me I do have it in front of me, Your Honor. I think page 13, is her penultimate paragraph there.
Which is background, correct? The discussion, it's some factual background about the case.
Yes, the discussion. That's at the end of the decision. That seems to be her summing up of the findings that she made. So that there is pretty telling. And I'm not sure where else it speaks to that in the opinion, but that I think there, it's not specifically discussed in the factors, but I think there that she's really trying to condemn him for the lack of moral courage or moral fiber to stop the other man, which I don't think is appropriate, because we're here to discuss his risk and his dangerousness, not the other man's.
So let me ask you this. Record Appendix 36, this is the amended decision at page 4. The hearing officer sets forth the standards for the review, and says the hearing examiner is not limited to the risk factors delineated in 803 CMR 1.33, rather may consider any information useful in assessing risk of reoffense and degree of dangerousness. Do you, just as a preliminary matter, do you agree that that's an accurate statement of what may be considered?
Yes.
Hearing examiner?
Yes, I do not dispute that that's what they can consider things outside the enumerated factors.
So why is her notation of the petitioner's lack of concern regarding the actions of the co-defendant, and then she specifies that there's no evidence that she was consenting to the touch of the other man, that the victim was intoxicated to an extra vulnerable degree and unable to consent or protect herself? Why is the hearing officers noting the petitioner's lack of concern not useful information?
Because I think it goes to his to a general issue of should he have intervened? Did he have a duty, even if it was just a moral duty, to stop the other man or at least protest in some way? Now, let us also don't forget that the victim was not so intoxicated that she was unable to recognize a stranger and would have perhaps protested if some random stranger came up to her and started groping her. That was not the case here. And we do not have a situation where that might have been a concern if these two had known each other or had planned something beforehand, or they'd come to an agreement where, at that case, you might be able to contribute some kind of misconduct from the other man to this man. But here it's just a situation of he didn't act perhaps as he should have acted, and therefore I'm going to find that against him, even though even the police don't have a duty necessarily to act in situations where they clearly should be required to act.
Are you saying that she had the capacity to consent?
I'm not. No, that was no. I don't. That's not an argument we can really make, that she did not have the capacity to consent. But But I am noting is that this is not a situation where now there was no issue that the petitioner and the victim knew each other. But there was also no indication.
If I may, I am just going to interrupt for a second. I'd like to give you a clearer question, which is, if she didn't have the capacity to consent and the petitioner knew that this other person was doing these things, is that not some evidence that the petitioner viewed that as all right, and given what he was already doing, may have intended to do the same himself? In other words, leaving aside whether or not an intervention should have taken place and whether that is an appropriate consideration for the board, is the fact that he tolerated it indicative of his behavior and his intent?
Well, obviously the petitioner recognized that he had a lapse in judgment that day and should not have done that. But whether he tolerated the other man's whether he tolerated the other man's conduct or failed to do anything about it, I still feel should not be raised in this argument, because ultimately he doesn't have the burden to show what he should have done or should not have done. Or
no, but couldn't the hearing examiner draw an inference from the fact that he apparently thought this was okay, as to what his own intent was and what his own actions meant?
Well, I think we find the articulation of that in my brother's brief. I do remember reading something along those lines. However, my brother can't provide. I don't receive that in the hearing examiner's brief. If the hearing examiner wanted to articulate that, I feel that she has the burden of doing that in her decision, because ultimately that's what this court has to review, not post hoc justifications for the statements given in it. So if it's not there, we are kind of speculating as to what the hearing examiner really meant, or what she meant to infer or imply in her decision, and that's not really appropriate. Now, one thing that also we're being asked to infer is touching of the breast. Now, there is a report from one of the witnesses that said that the petitioner was touching or feeling the victim's breast, but that was not specifically found by the hearing examiner. She talks about kissing. So I think that's important, because the breast groping is an escalation. She was happy to talk about what the other man was doing, touching the thigh, the inner thigh, the back, the chest, whatever he did. But my client is really being judged upon inappropriate kissing and touching of an undetermined nature. So
even assuming that that's correct, though, Mr. Stiles, isn't that enough?
It's obviously enough to find him guilty of the crime that he was convicted of, indecent assault and battery. However, we're not here to judge him criminally, but to determine whether he is a risk of reoffense. He has a risk of reoffense and a degree of danger, and that was just that there was not substantial evidence for that. But when we look at danger, we do look at what was actually done. And kissing in public is not particularly an objectionable practice, and it wouldn't have been if this victim was not intoxicated, even if it did rise to the level of making out, as I think it was said once in the decision. But when it gets to breast groping, that does rise to another level of danger that the court would have to otherwise consider if so found. But although it was reported, it was not specifically found in this case, and I think it should have been. So ultimately, I am asking the court to find that there was that the errors. And finally, there was also the issue of the probation. That at the time of the initial decision, the petitioner was on probation, and the hearing examiner gave him credit for being in compliance with his probation. However, by the amended decision, he had finished his probation, and the hearing examiner withdrew that mitigating weight. But at the same breath, she should have considered that he had successfully completed his probationary term.
Attorney Stiles, I'm sorry to interrupt you again, but was there evidence in the record that he had successfully completed the probation? I accept what you're saying about the record evidence of having been in compliance with probation at the time of the original hearing, but subsequently, was there evidence that there had been successful completion of the probation?
The only direct evidence was that there was that probation was over. And I would note that there are instances that had the probation not been successful, it may not have been over. And I think the board would have been able to show pretty quickly that there were probation violations, that this probation was extended, and ultimately the board has the burden to show that there was a less than successful completion of probation. Without that evidence, the only assumption that is there is that he did complete it without incident. And for that, the board even recognizes its reclassification regulation. That's 803 CMR 1.312C3 of successful completion of probation can be useful in judging, at least in reclassification. I don't see any reason why it couldn't be in this case. So I think that, again, between those errors, once you take away them, I would request that the court hold that there was not sufficient weight to require the petitioner to register as a sexual offender. And if there are no further questions, I will rest on my brief.
Thank you very much. If you just wait until the 15-minute light emerges, counsel, you will proceed. Thank you.
Good morning, Your Honors. David Schneid for the board. I think we have to look at this decision, not the original decision, to determine whether or not the hearing examiner's decision supported a finding that this individual, by clear and convincing evidence, was a level 1 sex offender. This is an oddity in the sense that this individual in 2017, just 2 years before the final classification decision was issued, sexually assaulted this woman with another man on a park bench while she was intoxicated in the middle of the day. I don't know how you can get around not saying that there's a cognizable risk, since this only occurred a couple of years later, that if another female found herself in that situation, she might also be subject to this type of assault by this individual. The attribution to the co-defendant, I think I handled that well in the brief. She wasn't attributing his action. She was pointing out that this individual not only knew this woman and was supposedly friendly with her, but he was allowing this individual to sexually assault her while she was intoxicated, which was also an indication of his own thought process at the time. And I think her statement in the hearings, in her decision, where she says that she noted the petitioner did not care to protect the victim from the other man's indecent assault. And I find that he also had no concern about his own behavior. I think she does a good job of pointing that out. And then lastly, I think on the probation issue, Factor 28 is applied when an individual is currently on probation at the time of the classification. The idea being, and the factor says specifically, that an individual who's currently on probation or parole, there has a reduced risk. By the time he went back to the amended classification, he was no longer on parole, or I should say on probation. So therefore, that credit did no longer existed. Now, Factor 13, which covers...
Sorry to interrupt you, but it seems a bit odd that someone who completes probation, and for purposes of this question, assume that Doe successfully completed probation without incident and complied with all terms. It seems strange that under such circumstances, Doe would lose that mitigating weight by doing everything he was asked to do, as opposed to merely being on probation, where he could be, frankly, screwing up left and right. And yet, under this application, he still gets full mitigating credit. Doesn't there seem to be a tension there between those two scenarios?
Well, actually, there's not, because once he's no longer on probation, Factor 13 is the issue. And Factor 13 specifically is applied when people violate probations, but it specifically says offenders are expected to comply with probation. They don't get extra credit for complying with probation because it's presumed that individuals should be doing that anyway. The change in that is that Factor 20, I think it's 29, offense-free time in the community, takes into account an individual who has been in the community for a certain period of time and has committed no offenses or caused any problems. So once he's off probation, Factor 13 only looks at whether or not he had violations because it's a high-risk factor. If he hasn't, then the issue becomes, has he been in the community long enough under Factor 29 to get a credit for being offense-free? And this individual obviously had committed the offense 2 years prior to the offense, hadn't reached that level because that factor says you don't really get a credit for it until you've been in the community for 5 to 10 years without committing new offenses or misbehavior. So
the factors give zero weight to complying with what can be stringent and difficult conditions of probation.
On its face, it does.
But gives full credit just for the fact of being on probation. You're right. Maybe those aren't inconsistent, but that still strikes me as strange is the word I'll use.
Well, not necessarily, because if an individual has been on very stringent, and this individual, I don't believe probation was that stringent. But if you're talking about someone who's on all types of and for a long period of time is on probation, has stringent requirements, the hearing examiner can consider that as other useful information. The issue and the idea of Factor 28 is if you're currently on probation, that means you're being monitored. And if you're being monitored, your risk is reduced during that period of time because someone's got eyes on you. Whether it's once a week, whether it's once every 2 weeks, you're reporting to somebody and they're paying attention to your activities. Once you're off probation, that protection no longer exists. And that's the reason why there's a credit for someone who's on probation at the time of the classification. Unfortunately, like I said, Factor 13 only deals with people who have been on probation and have not been able to comply with probation because that's indicative of antisocial behavior. And again, that factor starts with the premise that people are expected to comply with probation. I think once someone's off probation, the way to look at his behavior, even while he was on probation, is, I shouldn't say even while he was on probation, but the way to look at his behavior is how long is he in the community offense-free? And that's where that factor kicks in. So I don't think there's a tension between them. I think it's just a differentiation about which each factor is designed to do. And again, the hearing examiner can take other information as useful information into account in certain circumstances. If an individual has completed a very strenuous and long probation, that might be something they would consider. I'm not saying they would or wouldn't, but they have.
Yeah, have you, in your considerable experience doing this, have you ever seen a hearing examiner consider that factor, or rather use that as other information, use that other information category when it comes to probation completion?
I'd have to say off the top of my head, I can't think of one, but I'm not saying that it hasn't happened. I just don't know off the top of my head. Yeah, I've been doing this since 2005, and I'm not. They all kind of blend together, but I'm not positive that I've actually seen that happen. I can't say that it hasn't, and that's the only thing I can really say about it. I haven't seen it personally. That doesn't mean it hasn't happened. I do take on a lot of the appeals, but at the same time, there's right now 10 other lawyers handling cases, so I don't know what they have in front of them. But I think I've addressed these issues fairly well in my brief. And unless there's other questions, I'd be happy to rest on my brief.
Could I just ask one, Attorney Shania,
Sure.
which is, did the hearing examiner need to account in any way for the fact that the gap, so to speak, in which he may have fallen between consideration on the positive end for participation in or being subject to probation and his inability to reach the offense-free time in the community had something to do with the fact that the SORB examiner applied the wrong standard in the first case, required a rehearing, and in that gap was making a decision based on the information. I'm not articulating that very well, but when the original decision was issued, he had the benefit that he did not have when the second opinion was issued, and the reason for that difference in part was the timing of the decision. The reason for the timing of the decision was an issue with SORB's application of the standard of proof.
But I think there's two ways to look at that. The first is, of course, when the hearing examiner is making the second decision or the amended decision, again, she's looking at current risk at that time, current risk in danger when the decision is issued, not when originally it was decision. And again, someone's risk or danger can change in that period of time. In this case, it was initially a 1. She found him to be a 1. And then on the second amended decision, she still found him to be a 1. And I don't think the evidence, even if you said he should have got credit for that current probation, I don't think that would have, if you look at all the evidence in here, still reduced him below a level 1. I think the actions that he did less than 2 years before the actual amended classification decision show that he does have at least a level 1 risk and danger at the time of that decision was issued. Now that may change and would be 3 years when he'd be eligible for a reclassification. But right now, in the 2 years after that incident, I think the incident was such where you could say he does pose a possible risk and a possible danger at a level 1. And that's important because if he does reoffend, a level 1, no one really knows he exists in the community except for law enforcement and the board. It's really there because if this individual in the next couple of years decides to reoffend again or do something that shows his risk is rising, the board can then go through the reclassification process as opposed to waiting for a conviction and then starting the whole classification process over. So it's awaited for at least until he gets terminated down the road for the board to keep track of him somewhat. And that's really why the level 1 exists. And I think this individual's actions in 2017 put him in a category where the board found that his risk was a level 1, his danger was a level 1, and that he should be at least have some monitoring going on by the board and law enforcement until at such time where the board can no longer establish down the road at a reclassification, which could happen, can no longer establish that he still has a risk and danger by clear and convincing evidence. I don't know if that answered the question as succinctly as I would like to have done it, but I think I got the message out. So again, if there's no further questions, I'd be happy to rest on my brief.
All right. There appear to be none. Thank you both very much.
Thank you, Your Honor.
Okay, we are live and on the record.
Thank you. Good morning, everyone, and welcome to the May 7th sitting of the Massachusetts Appeals Court. My name is Mary Sullivan, and your panel today will consist of me, Justice Eric Nyman, and Justice Catherine Hand. The usual rules of oral argument apply in this virtual setting as they do in a courtroom. Each side will have 15 minutes in which to present its case, and there will be no rebuttal. We hope there will be no technical issues, but if there are, we hope that you will be patient with us as we are patient with you. And for those of you who may be watching On live stream, the screen may go dark. Rest assured, we will return as soon as the technical problems are fixed. And finally, you may see one or more of us look away from the screen from time to time. We mean no disrespect. And we, in fact, are giving you our full attention. It's just that the briefs and our notes are to one side of the camera or another. And on Zoom, just the merest turn of the head is amplified. With that introduction, it is now time to call the case. And I need not remind everyone involved that this case is impounded. It's 20P1152, Department of Children and Families versus Mother. And with that, counsel, as soon as you see your blue light with time, you may begin.
May it please the court, my name is Ilse Neering and I represent the mother. Over the course of the 18 months preceding here, which was the course of the child's entire life, the mother presented incontrovertible evidence for 72% of the time that of her substance abuse disorder treatment and her sobriety. For the remaining 28% of the time, she didn't document. There was no competent evidence of relapse or societal integration. In fact, she worked full-time and she presented herself to a DCF office regularly for her supervised visitation. Because a social worker told her that she wouldn't be reunified with her child unless she was in a substance use disorder treatment program residential, on the child's first birthday on November 27th, 2017, she entered into residential treatment. And at the time of trial, she was in a program specializing in substance use disorder treatment for mothers and to reunify the mothers with their children. And at trial, she called the director of the program in, who was qualified as an expert in substance use disorder treatment. And between the mother and the expert, they presented a realistic plan for reunification with this child. And that would be within 3 to 9 months, the mother and the child could go into the Institute for Health Recovery program, which is under the Department of Public Health, and that the mother and child could live together there. The mother would receive substance use disorder treatment, would work, and the child would be in daycare. And at the end of 2 years, if successful, the mother and the child would be moved into permanent housing. So the mother had recent positive gains and presented a realistic plan for reunification. And in this framework, I would like to discuss the errors underpinning the termination of the parental rights. So first of all, I would like to argue that it was error to determine that the mother abused, neglected, or endangered the subject child by exposing the child to cocaine in utero. If we read DCF's regulations at 110 CMR 2.0, the regulations clearly define that a child does not include unborn children. And
this is in fact the case, but may the department take into consideration the fact that the child was born with substances in their system?
Could you please repeat the question? I don't understand.
Leaving aside in utero exposure as in utero, once the child is born, may the department take into consideration the fact that the child has substances in their system when they are born?
Yes, I agree to that, Your Honor. I mean,
So leaving aside whether or not the judge made a separate finding about in utero exposure, the judge could permissibly take into account that the child was born substance.
Yes, but the statutory definition required for that particular under 210.3 required a finding of abuse and neglect and an inability to benefit from the services provided. So if the mother isn't, abusing and neglecting the child, that first prong of that very powerful second statutory basis for termination.
Are you saying it's not evidence of abuse and neglect for a child to be born with those substances in their system?
I'm not qualified to make that, but I only point to the adoption of Catherine, where the court declined to decide whether the transfer of cocaine to a fetus was abuse. And the court noted that—
We're not talking about the fetus. We're talking about the child once born.
But if the mother, if the act then ends and the transfer between the blood ends and the mother isn't committing any action towards the child to produce more, put more cocaine in the child's blood, then that ends. I mean, the definition of abuse is requiring some activity on the caretaker. Once the child leaves the body, the caretaker isn't acting on the child.
So that you're positing that even if a child is born substance exposed, that the department is prohibited from taking into account the fact that the mother exposed the child to substances?
The department, I think there's a distinction.
Or the judge?
I beg your pardon?
Let me take it away from the department. Are you saying that the judge, faced with a child who's born exposed to substances to which I think we can all agree a child should not be exposed, cannot take into consideration the fact that the mother exposed the child once born by her past actions?
I agree that the judge can take it into consideration, but for the purposes of 210 section 3, or that there has to be, it's two-pronged. First of all, that the child has been abused or neglected, and I read abused and neglected is defined by DCF's regulations because it goes together. And then for the second prong of section 3C2, then the mother failed to avail herself to the services provided to correct the circumstances which caused the abuse and neglect. In this case, once the child leaves the body, then the mother it's abuse is the non-accidental commission. Well, the mother isn't intentionally committing an act after the child leaves the body to put the cocaine in the blood. So she can't be, under the definitions, abusing the child, and she can't be neglecting the child because, well, she's not even the care, that's defined as food and clothing. And so that,
well, the judge didn't really place very heavy. She noted that the child was born substance exposed, but her primary focus was on the repetitive pattern of attempts at recovery and relapse. And her finding was that she did not see that this particular situation was sufficiently different to believe that the mother would be able to care for the child. What do you say to that?
So my argument about that is, so the judge finds, the judge is very focused on a 6-year period of substance use treatment failure. And my position on that is that the first 3 years of this alleged failure is predicated on inadmissible hearsay, which entered into evidence over objection and an absence of exception. DCF provided, the evidence was in this affidavit attached to the petition, where the mother objected to opinions, diagnoses, and prognoses that the mother had been in treatment for a period of 3 years and had failed, and coming up through to 2017 as the reason why the DCF should get custody of the child. But there was no competent evidence of substance use disorder treatment up to 2015 if this incompetent evidence is removed from the equation.
Well, this case was tried before adoption of Luke, was it not?
But even before the adoption of Luke,
do we agree on that the case was tried before adoption of Luke?
Yes, Your Honor.
And then would we apply the holding and adoption of Luke regarding the admissibility of the evidence to our review of this case?
I don't think that Luke really applies to the objection to the affidavit. There was multi-level hearsay in other
The affidavit
instances.
accompanying the petition, you mean?
Right, Luke.
Yeah, let's put that one aside for a moment. With respect to the medical records and the treatment records about which you were just speaking, do we agree that adoption of Luke and adoption of George apply to the admissibility of those records?
Well, so there was medical record evidence at issue in this case, and that was about blood tests for a child called D and the mother's urinalyses. Or is the court asking a question about substance use disorder treatment records as medical records?
The latter.
Oh, well, there were no objections made anywhere on the record about substance use disorder, the mother's treatment between 2012 to 15. For that reason, Your Honor, it was basically focused objecting to the opinions, diagnoses, and prognoses in the affidavit. But then later on, the mother herself testified to her treatment between 2016 and 2019. And that is, I see Your Honor smile. So yes, the mother admits that there was 3 years of solid evidence of her substance use disorder treatment. And if that answers the question, that the mother struggled, yes, in 2016 and 2017, but from the moment this child was born on November 27th, 2017, she turns her life around, and she pretty much within a week of the child's birth enters into residential treatment. And she documents over the 18 months of this proceeding her treatment for 72% of the time. And
so the judge found that she had a pattern of doing really well while she was in the structured treatment programs and relapsing upon release. And on that basis, determined, and I don't like the word statutory, the statutory term unfit, but it's the one we have to use. I fully recognize that this mother has made a significant effort in this case. I think we all do, and we all commend her. But the finding which we are reviewing is one made by the judge that there had not been sufficient progress to warrant confidence that she would not relapse again. I've put it somewhat inarticulately, and I didn't totally hew to the statutory language we would use, but I think you take my point.
Well, I would be from during, well, the only evidence of the mother's relapse in this case, again, I would argue in the 18 months from this child was born was incompetent evidence. And that's third level medical record hearsay, which was objected to that at Campbell House that she tested positive once. And also to
take that out.
Then the only evidence is
a multi-year track record of structured treatment and relapse.
We have 2016 up to the child's birth in 2017. And then after the child's birth, we see that for the majority of the case, she has incredibly long periods of sobriety. The only evidence of lack of sobriety is inadmissible hearsay of what a urinalysis screen says at Campbell House, and hearsay in a report that she was in constructive possession of drug paraphernalia. And we balance that to her testimony which she gave her side of the story, and the judge never told us why her testimony was not credible and hearsay was reliable because it was detailed and corroborated. We don't know.
You've only got a few seconds left. Would you like to address the affidavit?
Well, the affidavit, the mother objected to it. And in addition to that, it is a pleading. And pleadings are inadmissible. And the mother, under the law.
Was the evidence contained in the affidavit otherwise in the record through sustained 51B reports or other records?
The mother objected to a lot of background information in those reports. Thank you.
All right, thank you very much. I'm not sure which of you wishes to go first, Attorney Bayless or Attorney Cantor. Okay, let's wait until your timer goes up. You may proceed.
May it please the court, Jeremy Bayless for the Department of Children and Families. This is a case where a mother has, as Your Honor noted, a years-long history of very unfortunate success. Well, the success wasn't unfortunate, but unfortunately, periods of success followed by relapse. Mother herself admitted that she struggled when she became complacent with her treatment, which is what would happen after a period of success in a program. In putting aside the contested evidence of her substance abuse and her various discharges from treatment programs during the life of this case, Mother herself also admitted to getting into a fist fight with and assaulting another resident at one of the treatment programs she entered into, which led to or contributed to her discharge from the program. So even without the challenged evidence about Mother's ongoing struggles during the case, there is competent evidence that was considered by the court that Mother continued to struggle with her ability to maintain and meaningfully participate in the substance abuse treatment programs that she was relying on to be her long-term solution to render her able to care for her child. There was sufficient evidence in this record to support the court's decision. Your Honor correctly notes that this is one of the sadder types of cases we have where a parent is doing better. It's uncontroverted that she's better now than she was before. It's just not enough better to make the court, I guess, to refute the department's case and the reality that this parent is not sufficiently better, that her unfitness is unlikely to continue indefinitely. This is a parent who stipulated to the termination of parental rights of 2 older children due to her substance abuse problems. That evidence is properly considered, and while there was very little that this child was directly exposed to, that was because this child was removed after testing positive at birth for substances and in consideration of the mother's history. The courts and the department are not required to wait for inevitable disaster when presented with a track record that indicates that a parent is going to go in that direction. Furthermore, to the extent that my sister is challenging the factors justifying the removal of the child, that was more properly the challenge at the time of the 72 and was rendered moot by the process of a full trial.
But leaving that aside, can the judge take into account the fact that the child is born substance exposed when the exposure exists at a time prior to birth?
Yes, Your Honor, and I would say that the judge, in fact, has to. In the same way the judge needs to.
What's your best case for that?
I off the top of my head, I unfortunately can't think of one. The general principle is
we have carefully carved out fetal exposure, so it's as a separate issue.
Yes, I understand the argument in the position that this is, it's not capable of repetition. The child is only in utero once, and under the regulations, it is not yet a child for the purpose of the abuse or neglect statute. However, the case law has long held that the court can use a parent's history to anticipate or determine what is likely to continue. And to parents, even if it's not at the time of the substance use, an act of abuse or neglect because the child isn't born yet, it is still evidence of a poor judgment that the court can consider when determining whether or not the substance use disorder is being adequately addressed later. It is also evidence of poor judgment that, as Your Honor noted, once the child is born, does have an impact on them, even if it is not within those very specific bounds.
With an illness like substance abuse, we don't necessarily need to talk about poor judgment, do we? It's evidence that the mother is still suffering from a substance abuse disorder at the time of the birth.
Your Honor is correct. That was inartfully phrased. It is the evidence of
continued drug use.
Yes, that is that has a consequence and has an impact on the child, and is a history that can inform the judge's decision.
What do you say to the evidentiary issues?
Well, I have several responses. While Luke was decided, the SJC decision in Luke was decided after this case was tried. The appeals court decision was in place, and while obviously the SJC decision supplants the appeals court decision, the appeals court had affirmed on substantially similar grounds. And so the idea that the attorney was not on notice of the need to subpoena identified hearsay sources found in public records is simply false. As far back as 1989 in George, 1990 in Michelle, it was made clear that when there is identified hearsay, in George, it was specific to these sort of routine clinicians, service providers. When that's identified in a public record, including DCF reports, that given that these are professionals who have heavy caseloads and may not have a strong personal memory, there was little to gain and much to lose by requiring all of those professionals to testify live. And so George held that the proper approach was, if the source of hearsay is identified in a public record, that the remedy is for the challenging party to subpoena that source to cross-examine them. In Michelle, the court noted that there was no distinction in the case law between levels of hearsay. The operative factor is that there is an identified source that can be called in to challenge. That's been the system for over 30 years.
Doesn't the affidavit stand on a different footing, though? Why? I understand why there's an affidavit attached to the petition in order to commence the proceeding. But why was the affidavit an exhibit in this case? And if so, why? Because that would appear to be just pure hearsay. It's not a departmental record. It's a document prepared for litigation.
While Luke was not written at the time of the trial, its analysis is informative. When the court lays out the sort of departmental records, it specifically includes in that sort of string explanation site DCF affidavits. The affidavits are they are created to, for lack of a better phrase, part of their purpose is to consolidate information that would be testified to, because the social worker is more than capable of testifying. But the easiest answer, Your Honor, the one that should be reached, is that the juvenile court judge cited her findings. And at no point in the findings did she cite to the department's affidavit.
And was there anything in the affidavit that wasn't otherwise admitted in evidence?
Nothing that was relied upon. And so there might be grounds to speculate that there was unsight, but that speculation would be just that. It would be an assumption that the court acted improperly when the court's affirmative findings direct us to what she relied on to justify those findings of fact and conclusions of law. And those do not refer to the affidavit. So even if the affidavit was not properly admitted, that error would be harmless. And so if there are no further questions, I'll rest on my brief.
Thank you very much. Attorney Cantor, you may proceed when you see the blue timer.
May it please the court. Andrew Cantor for the appellee child. Your Honor, my argument dovetails quite a bit with that of my brother counsel for the department, but there are a few points that I'd just like to emphasize or clarify. The first is the parties are correct to address mother's history of relapsing. And Justice Sullivan specifically mentioned about mother's, I guess which term was the release into the community, that I guess there's a pattern, and that mother did well, but was not doing well upon, what I think was the word was released. I just want to clarify that mother didn't relapse when she was released into the community. The record indicates that mother had a history of relapsing while in treatment. And Judge, this is really significant and very important because the evidence was clear that anytime mother was in a very structured, very regimented program, she did well. But on several occasions, she was given a little bit more freedom when she transitioned to what was called a sober house. And each time on 3 occasions of being at a sober house, she relapsed into using cocaine. And so the judge at the lower court was perfectly correct in using that history as prognostic evidence of her continued unfitness and her likelihood to relapse. After all,
I had viewed the sober house as part of the release to the community, but I take your point. I mean, the level of supervision in a sober house and the level of treatment is markedly different.
Right. And so that's my point, is that if she couldn't achieve sobriety while still in treatment at a sober house, this is a long ways away from her being in the community where she would be expected to be a successful parent, drug-free parent to her child, my client. And so the history of her relapsing while still in treatment just further underscores the fact that the judge was right in finding her unfit and that her unfitness was likely to continue for a significant period of time. And so I just want to emphasize and underscore that I do believe it's very important as to upholding the decision below. Judges, as to the issue of in utero use, I just want to address that very briefly. And I think, again, Justice Sullivan, you were right in flagging the difference between in utero versus at birth. And even if you couldn't take into account in utero cocaine use, the fact remains is that the child tested positive at birth for cocaine. And there is certainly evidence, or there are a number of reasons that should be considered. Chapter 119, Section 51A, which obligates parties to report physical abuse or neglect of a child, includes specifically that the child tested positive for drugs at birth. So it would be perverse to obligate a reporter to identify that someone had tested positive at birth as evidence of neglect, but have that same evidence not be considered at a trial for unfitness. The fact remains very simply, Your Honors, is that mother neglected her son's well-being and her welfare going back to before he was born. She skipped prenatal appointments and had him born exposed to cocaine. And my sister counsel referenced adoption of Catherine, and a reading of Catherine again underscores why the judge was right to terminate in this case. In Catherine, although the mother used cocaine or the parents used cocaine, there was no evidence that the cocaine use had any effect on the upbringing of that child. Here, by the mother's own action of checking into rehab upon birth, that's her own tacit admission that she had a problem and needed to address it. The fact that she couldn't complete the program just again underscores that she had issues and continued to struggle with her drug issues through the time of trial. And so I would, that's the issue with the in utero. Finally, Judge, as to the evidentiary issues, I would just simply point out that mother failed to object to a number of the same topics that she addresses. So for example, the affidavit and the medical records that she claims was inadmissible hearsay. Mother admitted to drug use while pregnant with that same child. And so even if you exclude many of the issues that she objected to as far as her evidentiary ruling, all of the evidence that she didn't object to go to show that she's unfit. And so, judges, I'd just like to conclude by saying the trial court was right in finding that mother was unfit, right in finding that unfitness would continue for an indefinite period, and also right to find that my client's best interests were served by recommending that he be adopted by the pre-adoptive family. Thank you. I rest on my briefs.
Thank you all very much. That concludes your portion of the argument today, and I think we all do wish this mother well.
All right, we are live and on the record.
Good morning, everyone, and welcome to the final case of the May 7th sitting of the Massachusetts Appeals Courts. My name is Mary Sullivan, and your panel today will consist of me, Justice Eric Nyman, and Justice Catherine Hand. The usual rules apply. In oral argument, each side will have 15 minutes, and there will be no rebuttal. We hope to remain free of technical issues today. Along those lines, if either counsel is live streaming, if you would go off the live stream, because that will create feedback problems. But for any of you who may be watching on YouTube, if we have technical issues, your screen may go dark for a moment. Rest assured, we will be back, and we will do our best to resolve them and ensure that this argument is completed. And finally, if you notice any one of us look away or look up or look to the side, we mean no disrespect. We are fully attentive to your arguments. It's just that our briefs and our copies of the record may be to one side of this camera or another, and on Zoom, even the slightest movement of the head is amplified for all to see. With that, I will call the final case, which is partially impounded, 19P1482, Kimberly Briggs versus Robert Briggs. And Attorney Griffin, you may proceed when you get your 15-minute light up there. There you go.
Thank you. May it please the court, Attorney Kelly Griffin for the appellant Robert J. Briggs. The appellant is asking this court today to vacate the trial court finding of contempt and the ensuing order of attorney's fees as a result of his alleged failure to pay 1/3 of the cost of college for his adult unemancipated child. This case really hinges almost entirely on the requirement that we have for contempt findings that there in the first instance be a clear and unequivocal command. And the language of this agreement is such that there can be no finding of a clear and unequivocal command. We must be able to glean the clear and unequivocal command on its face. This agreement in particular directs the parties to contribute to college costs, quote, to the best of their ability. And it also directs them to do so in consideration of their respective financial circumstances at the time. It further directs them that their contributions will be only applied after grants, financial aid, scholarships, and loans. And finally, the agreement states that the total contribution of educational costs per year will be 1/3 each, husband, wife, and children, based upon University of Massachusetts tuition. There are several areas of this judgment that require further factual inquiry and substantive further analysis that make it impossible for the parties to simply read this agreement and know some certain that they are to contribute to the college costs. The term best of their ability is entirely subjective.
Well,
and
let me stop you right there. With regard to ability to pay, whose burden is it to demonstrate inability to pay?
If there were a clear and unequivocal command, such as a child support order, it would be on the defendant, on the payor, to show their inability to pay. We have a very different scenario here where there was no clarity as to the sum certain that would be owed because of the vagary of the judgment. There is a requirement that it is, yeah.
So if your client provided discovery and it showed that he had $20 million in the bank, and there was a dispute whether the amount to pay was $2,000, $3,000, or $4,000, would you be making the same argument?
I would be on the finding of contempt. I think if there was a question
in that scenario I just gave, and I'm sorry to interrupt you, but isn't the issue simply a factual determination of the correct amount versus failure to pay?
There has to be a factual determination of the correct amount before we can find someone knowingly and willingly violated a court order. So whether he had $1 or $1 million, how can we find that he has willfully and knowingly violated an order if we don't know what he was supposed to pay? And
well,
I don't know.
The record reflects on page 52 of the record appendix that Mr. Briggs was asked if he would prefer an evidentiary hearing or to proceed on representations. And he elected to proceed on representations. We also have it, there was a motion to quash heard that day that he had not provided certain discovery regarding his financial circumstances. And then later on in the hearing, a representation is made about the amount of tuition owed. This wasn't UMass tuition, it was Westfield tuition. So given that factual record and his agreement to proceed by representation, why aren't we there? We have an amount and we have a refusal to disclose financial circumstances.
I think one of the difficulties with this particular hearing, first of all, Mr. Briggs was pro se at this hearing. He was unrepresented by counsel, and the trial court judge on page 52 in that record appendix he informed the court he did not understand what the difference between an evidentiary hearing and a hearing on representations was. And he said, "I do not understand that, Your Honor." And the court then gave an explanation between lines 6 and 12 of the record. And the explanation the court gave was that it would be the difference between Mr. Briggs testifying on the stand versus Mr. Briggs testifying behind the tables. Now, query whether that is an adequate explanation to a pro se litigant as to what the difference between a representations hearing and an evidentiary hearing, and whether that's truly a full waiver, a knowing waiver of his right to an evidentiary hearing on a contempt proceeding. This was also a consolidated proceeding with a contempt and a modification at the same time. The discovery issue, he had filed the motion to quash. That ruling was at the hearing itself. And so following that ruling, he should have been given the opportunity to produce documents.
Well, didn't the subpoena tell him did the subpoena tell him to bring them with him?
They did. He filed the motion to quash with the understanding that pending the ruling on the motion to quash, he would not have to produce the documents. He didn't produce the documents. He produced a financial statement sworn under the pains and penalties of perjury. And the trial court specifically admonished him for the fact that he had solely produced a financial statement. However, that's all that the mother produced as well. Her financial statement was the sole document that she relied upon. It was the same short form, quote, bare bones financial statement that the trial court referred to as the father's. And her sworn financial statement did not include any reference to the college costs. She did not swear under the pains and penalties of perjury on her any of those college expenses.
Well, she wasn't her conduct that was at issue in this particular hearing. So the judge relied on the fact that there had been a substantial sale of real estate previously, and a failure to pay So how How would you say that should have been dealt with?
I would say I don't know how the reading of this judgment would have directed Mr. Briggs to a specific amount that he should have or would have needed to set aside for college costs. It does not direct him as to a sum certain because of all of the vagaries and conflicting aspects of the language of the judgment. A clear and unequivocal command should be one such that any of us could read it and understand what was to be contributed to college, and that's not the case. He also so his sale of real estate was several years prior to even his children applying for any colleges. There's also this statement, and Mr. Briggs indicates this in his representations, that he looked at the term contributions of the parties are to be applied after available grants, financial aid, scholarship, and loans to mean that his children would need to take out loans, and only if they were unable to take out the loans would he have to contribute a sum towards college. So 2 years prior to them even applying, there's an expectation he's to reserve some uncertain amount of money in his assets, which are a joint asset with his wife, not entirely his own. And he has 3 other minor children to support, 1 with the FLE and 2 with his current wife.
Well,
I don't see
the 2 with the current wife can't be used to reduce his support obligation.
Not to reduce it, but to add an obligation to him, or to have him be accountable for funds that he did not know the amount that he would needed to set aside. I do think it's relevant to that factor.
So this is not a case like Cooper versus Keto and some others where the language says agreed upon college expenses. This is a case that's a little bit different than many of the ones I've looked at, in that it actually has a concrete benchmark, which is the UMass tuition. What is your best case, legal case, published case, for the proposition that the language is ambiguous and is not clear and unequivocal?
I mean, I look at the Walzak v. Driscoll case, where vague or ambiguous language does not furnish a clear and unequivocal command. Now, granted, in that case, the vague and ambiguous language was joint consultation, but I would argue that statements like "to the best of their ability" and "in consideration of respective financial circumstances at the time" and the word "total."
Take out ability to pay for a moment, because I think we've got 2 separate issues here. Just concentrate on whether or not knowing he had to pay for tuition and what the amount of tuition was. What's your best case for the proposition that the language of this agreement is not clear and unequivocal?
I think the contrast between "in consideration of their respective financial circumstances of the time."
And I'm asking you to take that out.
Yep. And then
so the word, look at the amount of the tuition. What's your best legal case for the proposition that this language is clear and unambiguous?
I think even the modifier of total to total contribution contemplated that there could be less than a division of 1/3, 1/3, 1/3. It says total contribution. It's a maximum amount. And it's, if that's maximum amount, here's how it's divided. It's totally silent on whether it is, if it's less than that amount, how that's divided, and how does this application of grants, scholarships, and loans impact the total contribution. I don't see how how there could be an amount that one could know that they owed by reading this judgment, even if they knew what the total amount of the college cost was, because how it's divided is dealt with so vaguely amongst the 4 sentences of this judgment.
What would be clear and unequivocal?
That's my question.
If it was to say, if the word total was not in that last sentence, I think it would be much clearer that the contribution of the parties was to be 1/3, 1/3, 1/3 up to the cost of UMass. I mean, it's an agreement that was drafted by the parties. That word total was there for a reason. I think if that word wasn't there, we would have a much clearer order. I also think if it was modified to say whether this loans were loans of the parties, loans of the student, and I think if there was nothing about considering the parties' respective financial circumstances, it's conflicting language, which is really the issue here. I did want to address one small issue since we're nearing the end of my time. There was a statement in the FLE's brief that there is no amended judgment for modification in the docket as it related to, there was a joint, a notice of appeal that both addressed the modification and the contempt. We voluntarily dismissed our appeal on the modification. There is in fact an amended judgment of modification in the docket. The docket sheet, unfortunately, refers to it as an order, but the actual docket itself, if on that docket entry, contains an amended judgment of modification dated as it was referenced in our brief. And unless there are further questions, the appellant is happy to rest on his brief.
Panel? Seeing none, thank you very much.
Thank you.
Attorney Quigley, you may begin when the timer goes back up. And you need to unmute yourself. Please proceed.
I don't see a timer. I'll do my best to watch it on my end. Number one, well, may it please the court, John Quigley Jr. for appellee Kimberly Briggs. First of all, I'm very sorry if I'm late. I didn't know there's only 6 cases on the docket. I saw 7 this morning. I was told to be on 15 minutes prior.
You're okay. Go ahead with your argument.
I beg your pardon. The first argument is that this is not properly before this court for the reasons cited in our brief. The notice of appeal was filed by defendant on May 6th of 19. That was filed prior to the order of the court on May 20. No subsequent notice of appeal has been filed. Defendant was invited to comment on that as per the court's interlocutory order. Respectfully, there is no jurisdiction here because the notice of appeal has not been properly filed.
Are you familiar with Roach versus Malika? 481 Mass 164 Note 2.
No, I am not, Your Honor.
I understand your argument in Eister versus Penachek. We had treated it as jurisdictional. The SJC in Rock or Roach, I'm not sure how you pronounce it, has suggested that we look at a more functional analysis and whether or not the reasons for Rule 4A have been violated in terms of the timing of the appeal. So
let's try the argument.
I express no opinion one way or the other, but they took a different approach.
Okay. As to the merits of the contract, respectfully, it is not ambiguous. I think the whole tenor of defendant's argument, it has been the case from day one, he's going to exhaust any means by which he doesn't have to pay. That goes for child support, it goes for college, it continues to go for college. 1/3 of the cost of tuition and educational expenses capped out at UMass, to the best of the ability, to the best of the ability of both parties. Look at all the relevant facts around here. He has, per his own testimony, a close relationship with his daughter, sees her constantly. She is applying to colleges going back to the spring of 17. He has observed her visiting schools. He has applauded the fact that she's not going to top shelf schools. She's not applying to private schools, or she didn't matriculate to one. She did apply to one, and she's going to a lower tier cost-wise school in Massachusetts. He just doesn't want to pay on that. He further, I'd suggest, has elementary unclean hands. He wants to purport to have a ignorance. I didn't know the cost. It was kept from me. Mom failed to provide it to me. It was sprung upon me. There's no duty on mom to provide it, number one. Number two, it was indeed provided and discussed between the parties multiple times. Don't now say, I'm
Is that in
surprised.
the record, sir?
Okay. He has had ample opportunity himself to investigate any of this. And I don't think there's any dispute about that. To the extent that he is now claiming ignorance, that is a willful ignorance. It shouldn't be rewarded. As far as the ability to pay, it is an objective standard. Child support, alimony, there are tables, there are guidelines. These are objective standards. Parties may disagree about what they can or cannot afford. That's why there are those guidelines to begin with. The burden is on him to prove his inability. He certainly rolled the dice. Number one, if he's coming to court pro se, that's his election. He produced no documentation. He filed his financial statement on the date of hearing, clearly based upon discussions prior to coming to court. He knew what the issues were relative to can you or can you not pay. Specifically, he was served with a subpoena to produce documentation that would shed light on that. Bank statements, whether or not there were retirement contributions, disposition of $110,000, and I dispute that it was found that was received a few years prior. He chose to provide none of that. The court is the sole arbiter of his credibility. It found it to be wanting to the extreme. It was his burden to prove it, and he not only didn't satisfy it, he made no effort to satisfy it. None at all.
Attorney Quigley, could I ask a question on a little bit different, not on a different prong of or part of the question, not on ability to pay, but back to your sister's argument about the ambiguity or whether it was a clear and unequivocal order. Looking at the language of the separation agreement, and putting aside the issue of the best of their ability language, without considering that, what do you say about the husband's arguments about the language talking about in consideration of their respective financial circumstances at the time, and the issue of how the question about other funding sources come into the husband's ability to understand the order?
Forgive me, Judge. Number one, would you repeat the two issues?
It was a terrible question. So putting aside the first language in the first line saying to the best of their ability, putting that aside, as to the rest of that provision of the separation agreement, what do you say about the lack of, for a better term, some certain amount included there about what the husband had to pay?
What I'd say, Judge, is this was crafted when their daughter was a freshman in college. It is foolish to contemplate that we're going to be able to hypothesize whether the child gets a 4-year free ride to Harvard on a volleyball scholarship, or because she's a math prodigy, it is purely speculative, and it's not possible to identify that, A. B, if there were any such question, raise it at that time, or raise it in the years, emphasize years that follow before now trying to take refuge under that I don't know what I have to pay. Number one. Number two, Judge, as a practical matter, let's stick to practicality here. The numbers that are actually he's been ordered to pay, even if you were to accept my sister's argument about a multitude of college campuses and a multitude of room and board and other various criteria, other elements, the number he's being asked to pay is on the virtual bottom of any of those calculations as to what his exposure is.
But am I understanding correctly that your argument is that the language from the separation agreement, although it doesn't nail down, for the reasons that you said or for any other reasons, a specific number, has a natural reading that would make clear what the obligation was.
Absolutely, Judge.
Just to clarify, Attorney Quigley, you said this provision was crafted when the daughter was a freshman in college. Did you mean when she was a freshman in high school?
I beg your pardon. Thank you for paying attention, Judge. Yes. Yes, I beg your pardon. 4 years prior.
I also noticed that we have University of Massachusetts tuition as the benchmark. Is the tuition the same across all 5 campuses, or was this intended to reference UMass Amherst?
May I suggest, Judge, that I can't speak for my sister, but that standard of calculus of UMass tuition has been used in at least 50 marital settlement agreements that I have seen. And I have never, so maybe if you want to call it a term of art or whatever, it was crafted by respective counsel in 2016. And I've always understood it, and my brethren have always understood it to be the flagship campus of UMass Amherst, including room and board.
Sorry, Mr. Quigley, is that included in the guidelines, the UMass Amherst standard?
I would have to, I can't answer you, Judge, I'm sorry.
I think it may be. Is there, I'd have to go back over the hearing transcript again. Is there anything in the record to tell us whether or not you've represented it? Is there anything in the record that tells us that the Westfield tuition is less than the UMass tuition?
No, there is not, Judge. It is information readily accessible for years prior to the date of hearing by defendant.
We're confined to the record, so. But there was a representation in the record as to what the tuition amount was.
And as your honors noted at the beginning, this was agreed to proceed by representation.
Okay.
I am asking for award of attorney's fees. I respectfully suggest that there is little prospect of defendant prevailing at the outset. A, B, this has been an extraordinary time pending. And C, despite my sister's allegations, Mrs. Briggs is being saddled and has been saddled with extraordinary fees on this for money that defendant should be paying without having to be brought to court. And I conclude if there are no other questions.
Seeing none, I thank you both. And we also wish to thank our clerk's office, our law clerks and interns, our security officers who continue to maintain the security of our building, and our IT department and all those who have made this virtual Zoom series of hearings this morning possible. That concludes this sitting. Thank you very much.